Hello, sir. Good morning.
Hello, good morning. Am I
How
audible?
are you, sir?
Very good.
Yes, yes, very nicely.
Very good. All set.
Yeah, just give me 5 minutes. I mean, some people are still getting logged in.
No problem. No problem. You can mute me, log, or should I put my camera off or it's okay?
Yeah, just for 5 minutes. I'll just announce it when we have to start.
No
You
problem.
can mute yourself and keep the camera off. Meantime.
I'll stop the video.
Yeah, yeah, no problem. Requesting everyone to mute yourself.
हाँ जी शर्मा साहब.
Anil sir, you can unmute yourself.
So shall we start?
I'll just mute a few of the members because they are like.
Sure, sure.
I request everyone to mute themselves. A warm welcome to everyone. Without any further delay, I request my colleague, Advocate Chinmay Vaidya, to give a small introduction for our chief guest.
Thank you, Shraddha.
Yeah.
Um, it is a great privilege for me today to welcome Mr. Anil Malhotra, sir, as a resource person for our lecture. Sir has completed his law degree from Punjab University and his master's from LSE. Sir has over 3 decades of experience in conducting civil, criminal, and constitutional matters in various high courts and in the Supreme Court of India. In addition, Sir has also been a part time lecturer at the Punjab University. He has co authored a book on NRIs and surrogacy in addition to other globally published works. As the chairperson of the task force of policy procedures and grievance resolutions for NRIs, Sir has authored over 5 papers for the government of Punjab that have helped in enacting various laws and acts. Sir has also conducted many intercountry litigations on parent child removal, child alienation, and child custody. Sir has been persistently advocating for India to sign the Hague Convention on interparental child abduction. His report, as the amicus curiae, has formed a part of the judgment of the Punjab and Haryana High Court, making a reference to the Law Commission recommending India be a partitionary to the Hague Convention. Sir has held many distinguished appointments in his illustrious career of over 3 decades, including as a resource person for training judicial officers at the National Judicial Academy, Bhopal, and at the Chandigarh Judicial Academy. Sir has also been appointed as an honorary professor in NUALS Kochi. It is a great privilege for us to hear Sir speak today, and I hope that we can make the best of his knowledge. Thank you. I now ask Sir to take over the session.
Thank you very much, everybody, for joining in. And I'm grateful to Shraddha ma'am for organizing this informative and very knowledgeable discussion. This is, of course, not the first, but it is one of the many. And she has always insisted on very invigorating topics on offbeat issues which are normally not in public knowledge. For me, also, doing litigations in these jurisdictions with new enactments has been a challenge. And I'm very grateful and indebted to Shraddha for giving me this platform to air my views so that information, knowledge, and inputs about this enactment can be shared with so many people who are actually oblivious to this enactment. Now, first of all, let me tell you what is the name of the enactment. It is a very unknown sort of a law. And in my span of 40 years as a lawyer, I had never heard of this until I had been appointed as an amicus by the High Court of Kerala on um, on 23rd of August 2023 to help the court in coming to a conclusion on how to help a guardian appointed under the Act, the NTA Act. The full name of the Act I'll read out. It's called the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act 1999. So the proposition which was there before the Kerala High Court was a Keralite couple, both uh, of Indian nationality, Christians by religion, who had a 21-year-old who had a 21-year-old autistic child or a boy who was with the father in Kerala, with the father in Dubai. And the mother in Kerala had got an order of being appointed as a guardian for the child in Kerala. So, how would the order of the relevant authority in Kerala under this NTA Act be enforced in Dubai was the question. So it was a very invigorating and a very challenging assignment. But I assisted the court to my best of my abilities. Now, before the court, there were two orders, two propositions. One was a habeas corpus, and another was a so-called challenge to the order of the local level committee under the NTA Act. Because the committee under the Act said, you are a guardian, but the child is not in the country, so we can't exercise our jurisdiction beyond India. So she had challenged that order, and she had also filed a habeas corpus. Now, the habeas corpus jurisdiction could not travel to Dubai because the habeas corpus ends within the territory of India. So, in their wisdom, the bench, assisted by me, said that the mother can go and visit the child in the consulate in Dubai, and some arrangement was worked out. But the order was challenged, Supreme Court stayed it, and the matter is still pending. And that is where the matter rests. But then I came across a judgment of the Delhi High Court, yes, in Sunil Podar versus NTA. Now, the citation I have given, otherwise it is 2023, volume 303, DLT 65. Now, in this case, the natural guardian and father, who was a US national and whose son was also a US national and who were living in Delhi, wanted to be appointed. The natural father wanted to be appointed as a guardian for his natural born son who was suffering from mental disabilities and needed a specific guardian appointment under this act. Now, the Delhi High Court, after going through the provisions of the act, the rules and regulations, came to the conclusion that the petitioner is the father of his son with disabilities, but because he's an American citizen, he has no vested right to be appointed as his guardian. So this is the proposition on which I wish to deliberate, discuss, and elaborate upon. Because the Delhi High Court is of the view that parent, relative, or any person, these words which are occurring in this act are only confined to citizens of India. Now, in my humble opinion, this limitation, this narrow view, to me, does not appear to be an enunciation of law which is compatible with rights of persons. So before we get into the judgment, let us first see what is this act named and what is it described as. So the act, as I just told you, is called the, once again, National Trust for Welfare of Persons with Autism Policy, Mental Retardation and Multiple Disabilities Act, NTA. So we'll call it for short NTA. So the objects of the trust, that is the National Trust, are to empower persons with disabilities to live independently, strengthen facilities with their families, and it goes on and on. Now, how does I'll read out the name of the act again. It's the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act 1999. So it's for short called the NT Act. Now, how does the trust constituted under the Act work? The trust is empowered to make local level committees all over India. So section 13 of the NTA says the board, now the trust functions through a board. So the board at the national level in Delhi will constitute local level committees consisting of an officer of the civil services, not below the rank of district magistrate or DC, representative of a registered organization, a person with disability as defined in clause so and so. So all over India, you will be surprised there is a local level committee and it is functional in practically every jurisdiction. So you have a doctor, an NGO, and a district magistrate or a civil services officer. So who is a person with disability? Person with disability means a person suffering from any of the conditions related to autism, cerebral palsy, mental retardation, or a combination of any two or more conditions, and includes a person suffering from severe multiple disability. So this is what it is broadly about. Now, how is a guardian appointed? Now, I want you to listen to section 14 very carefully. Section 14 talks about the appointment of a guardian. Now it says a parent of a person with disability or his relative may make an application to a local level committee for appointment of any person of his choice to act as guardian of the person with disability. Now I'm going to pause and I'm going to read this again, and I am going to highlight for you the word person, citizen. There is no word citizen here. So a parent of a person with disability or his relative. So first of all, the disabled person is a person, not a child. So this means anybody more than age of 18 can also have need to have a guardian appointed. So a parent of a person with disability or his relative may make an application to the legal level committee for the appointment of any person. Now here the word used is person, not citizen, to act as a guardian of the persons with disability. So this is the principal provision in the statute for appointment of a person as a guardian under the NTA. Then there are further provisions in 14. Now, then to implement the provisions of the NTA, under section 34, there are rules. These rules are called National Trust, so and so, Rules 2000. And Rule 16 provides a performa. Rule 16.2 provides for confirmation of appointment of a guardian. Then under section 35 of the Act, there are regulations. And regulation 13 talks about guidelines for receiving, processing, and confirmation of application for appointment of a guardian. So all these details are laid down, and in most jurisdictions, these committees are functional though the Act is of 1999. After about 2010, practically every jurisdiction has these local level committees. So, pardon? Hello? I can't understand what your question is. Can you please repeat it? There's a question. Anyway. So, under the Act, there is a board. The board has appointed committees by designation, 3 people, a civil servant, a doctor, and an NGO. Now, the offending provisions or the provisions which the Delhi High Court has read down are Rules 14 and Regulation 12. These rules prohibit according to the Delhi High Court, appointment of a foreign national as a guardian. So in the Delhi High Court, the natural father had challenged the vires of these provisions, saying that Rule 17 and Regulation 12 is ultra-vires the Constitution. Now, to answer the question, is there a common name for the committee? There is the committee is called the local level committee. So you have to probably go online on the website of the trust. Under the Act, there is a trust. It's very visible and transparent. If you keep going inside, It takes you to the local level committees. Then there is a list of jurisdictions in which there are local level committees. Then there is a list of which there is no committee. So when you go down to the committees, you will be able to get contacts or details of every committee, and further research will reveal the contact person. It's not a very difficult exercise. It's all available under the website of the trust. So now let us read what Rule 17 says. Now, Rule 16 talks about the application for guardianship. Rule 17 talks about procedure for removal of a guardian. It says local level committee, upon receiving an application for removal of a guardian with disability, shall appoint a team of 3 investigators. Now, very surprisingly, in the procedure for removal of a guardian, it is said, while taking a decision on the appointment of a guardian, the local level committee shall ensure that the person whose name has been suggested for appointment as guardian is a citizen of India. Now, citizen of India is coming in the rules. But as I just read out to you, when we read the section, the principal statutory provision, that is section 14. Now, section 14 says a person to act as a guardian. So it is a person who can act as a guardian. In the act, it is person. It is not citizen. It is not Indian national. Now, person, as you know, can mean a person of Indian nationality, a person of foreign nationality. Now, just to give you the very larger picture, we have foreign nationals who come to the writ court in matters of child abduction and their parents. They invoke Article 14, equality of law and equal protection of law, and Article 21 of the Constitution, right to life and personal liberty. Article 14 and 21 of the Constitution is available to persons. So foreign nationals come and file writ petitions. They are maintainable. But if you want to invoke your fundamental rights under Article 19, Article 19 consciously uses the word citizens. So it is in this context that I say that section 14, once using the word person, the regulation or the rules cannot water it down to citizens. I'll come to the reason why. But let us finish reading the provision first. Let us see what Regulation 12 has to say. Now, regulations are made under Section 35, rules are made under Section 34. Now, Regulation 12 says who may apply for guardianship. Both parents may jointly, or in the event of the absence of the one due to death, divorce, separation, desertion, or conviction, may singly apply for guardianship of their or the case, as the case may be, the ward beyond 18 years. Now, Regulation 12, who may be appointed, who may be indicated by applicant as guardian. Both parents, singly or jointly, in the absence of one due to death, divorce, so and so, being natural guardian, may apply to local level committee to get themselves or himself, as the case may be, appointed as guardian, or if the disabled ward is beyond 18, in which case application shall be accepted, unless the parent is disqualified on account of loss of citizenship. So this is where again the loss of citizenship has come. So the proposition and the point before the Delhi High Court in the judgment was, are the rules 17 and regulation 12 ultra vires the provisions of Section 14 of the Act, in as much that only citizens can be appointed, not persons can be appointed. Now, in the case of the Delhi High Court, the father was an American national. The child is an American national. Child is severely mentally disabled. Mother is divorced. The mother and father are divorced. Father has relocated to India with the child. We want to stay in India probably. But under the NTA 1999, he cannot be appointed as guardian. Now, let us see the anomaly in law. The natural guardian or parent is the natural guardian under Hindu Minority and Guardianship Act. Because Section 6 of the Hindu Minority and Guardianship Act says that the father and after him the mother, though they are both equal, shall be the natural guardian of the child. Even the Guardian and Wards Act says natural parent shall be guardian of the child. So in this case, the interpretation, in my view, given by the Delhi High Court does not seem to gel with reason. And reason is not just pure reading, it is reason of law. Now, let us see how and why did this enactment come? What was the reason for this enactment to come? Now, this act, and there is one more act, which is called the Right of Persons with Disabilities Act 2016. Now, before I go to the International Convention, I would also like to read the Right of Persons with Disabilities Act 2016. Now, in the preamble of this act, it is said that this is an act to give effect to the United Nations Convention on the Right of Persons with Disabilities. So there is a United Nations Convention, which is called the United Nations Convention on the Rights of Persons with Disabilities, which India has signed. Because India has signed it, that is why India has made these laws. So this is an act to give effect to the United Nations Convention, and it takes off all the rights, etc. And in this act, now, instead of going into all the details, I will just read. I will read for you Section 14 of the Right of Persons with Disabilities Act 2016. Now, 14 talks of provision for guardianship. Before that, caregiver discrimination. Okay. Notwithstanding anything contained in any other law for the time being in force, where a district court or designated authority, as notified by the government, finds that a person with disability who had been provided adequate and appropriate support, but is unable to take legally binding decisions, may be provided further support of a limited guardian to take legally binding decisions on his behalf in consultation with such person. So now again here, the word is that there is a guardian may find that a person with disability who had been provided so-and-so is unable to take legal decisions, may be provided the support of a limited guardian for taking decisions. Now, in this act, there is no restriction that the guardian has to be a citizen. So non-citizens are visualized to be guardians under this provision. Now, let us go to the principal provision of the convention under which all this issue has been crystallized in the best possible way. So, in law, when we in India as a country accede or accept or sign an international convention, we as a nation are duty bound to implement, follow, and adapt to all the contents of the convention to give force under domestic law. So, what is the United Nations Convention of the Right of Persons with Disabilities? UNCRPD. Now, first of all, Government of India has acceded and ratified the UNCRPD on 30th of March 2007. And that is why these enactments have come through. So, Article 10, Right to Life, state parties reaffirm that every human being has the inherent right to life and take necessary measures to ensure enjoyment of persons with disabilities on an equal basis. Article 11, situations of risk and humanitarian exigencies. Then access to justice, liberty of a person. Then Article 18, liberty of movement and nationality. State parties shall recognize the right of persons with disabilities to liberty of movement, to freedom to choose their residence, and to a nationality on an equal basis with others, including by ensuring that persons with disabilities have a right to acquire and change a nationality and are not deprived of their nationality arbitrarily on the basis of disability. Then Article 19, living independently and being in the community. Article 20, personal mobility. Article 22, right for privacy. Article 23, right, respect for home and the family. Now, once in effect, we have the United Nations Convention of the Rights of the Child, United Nations Convention on the Rights of Persons with Disabilities, acceded to in 2007. Can the 1999 Act prevail? Let us also bear in mind that there is a Right of Persons with Disabilities Act 2016, which has been made pursuant to India signing the UNCRPD on 2007. Now, my legal proposition is that if there is an enactment, that is the 1999 NTA Act, can the 1999 NTA Act be in conflict with the 2016 Act, the ROPDA, Right of Persons with Disabilities Act, and also the United Nations Convention on the Right of Persons with Disabilities? Now, the United Nations Convention on the Rights of Persons with Disabilities gives you freedom of nationality, gives you freedom of change of nationality, gives you freedom to reside in any country, and so on and so forth. In my view, the judgment of the Delhi High Court, which has not considered the United Nations Convention on the Rights of the Person with Disabilities and the ROPDA Act, would, with all humility, does not equate with Indian laws subsequently enacted. Now, I could have imagined if there was an interpretation to be sought. But here is a challenge to the very constitutional validity of the provision that in the regulations and in the rules. And the pointed challenge was that once Section 14 of the NTA Act does not limit the appointment of a guardian to a citizen or a non-citizen, how can the rules or the regulations make a provision contrary to the Act? I would add that there is much more than meets the eye, and that is the UNCRPD acceded to by India in 2007 and the ROPDA signed by India, enacted by India in 2007. Now, we must also keep in mind that we have also signed the United Nations Convention on the Rights of the Child. There is a child has a right to life, child has a right to a nationality, child has a right to a name. Then we have also enacted the Juvenile Justice, Care and Protection of Children Act, where again there are provisions of child being in a home, child being with a parent, and so on and so forth. Now, in the backdrop of this entire scenario, according to me, the conclusion which the Delhi High Court takes in saying the court thus comes to the conclusion that the petitioner cannot even claim a constitutional right to be appointed as a guardian of the person with disabilities. It draws sustenance from the following conclusion. Now, I beg to differ here. In my career and span of so many years in challenging or seeking return of children back to the country from where they were removed, we invoke the jurisdiction of the Supreme Court under Article 32 or the jurisdiction of the High Court under Article 226 for a foreign court order to be looked into in parents' portray for the return of a child if the child was removed illegally. Now, there is a constitutional remedy. There is a fundamental right under Article 19. I am not touching Article 19. It is a right given to citizens. So when a foreign national comes, I invoke Article 14 and 21. Article 21 is the right to life and right to family life. Article 21 says no person shall be deprived of his right or life or personal liberty except by procedure in accordance with law. So if the life and personal liberty of a parent abroad or a child in India, maybe foreign nationals, is disturbed, or it is maintainable, it's settled law now. I have recently got the return of a Dutch child back to Netherlands in 7 weeks after the matter was heard by the Bombay High Court at length. And the question of the constitutional remedy being maintainable is a settled question now. So for the High Court to say that there is no vested constitutional right would, in my humble view, be most respectfully not a decision which would be in consonance with law. Now, the other view which the court takes is that the child will be taken out of the jurisdiction of the court. The local level committee will have no control. Now, that is not a question for the local level committee, local level committee to answer, because that would most respectfully become a very difficult situation. Now, the question is that once the welfare of a person is concerned, then in such a situation, the facts require that the court ought to intervene and take care of the situation in the best interest and welfare. Now, if the best interest and welfare requires, hello. Now, if the welfare of the person under disability requires the person with the disability to be relocated abroad for reasons of medical treatment, for reasons of better living conditions, for cure of an ailment, for effective management of his or her bodily needs, what is wrong with it? Now, the convention itself talks of the betterment of the child. The international convention itself, if you can take care of the child effectively in such a way, what is the problem? So, in my view, taking the child out of the country would be not a limiting factor which would contravene the welfare of the child, because if the person appointed as the guardian is a natural parent, the natural parent already has the right to decide all issues in the welfare of the child. To say that the welfare of a child cannot be decided by a natural guardian because he is not the guardian appointed under the NTA would be perhaps a little out of place, because the parent of such a person with disabilities is obviously going to act in the interest of the person with disabilities, not against his or her interest. And if the guardian appointed under the NTA thinks it is necessary that better treatment can be given in Europe, in Australia, in Canada, or in England, because of advanced medical facilities, because of some issues of test, why should India be on a back foot of saying we will lose jurisdiction over the child? Once according to me, the local level committee appoints a guardian under the Act, the jurisdiction of the national level committee, except beyond certain safeguards provided under the Act or the rules and regulations, the role of the committee comes to an end. Unless there is a complaint or there is a reason for the removal of a guardian whenever there is something wrong or contravening the provisions of the Act. So, confining the interpretation of the word to parent, to citizens who are parents, relative, or any person, and saying a non-citizen cannot be appointed would, I think, be inconsistent with the welfare of the person for whose very benefit this act was enacted. And second, after India has acceded to the UN CRPD, United Nations Convention on the Rights of Persons with Disabilities, in 2007, I think the 1999 Act needs to be relooked, because the 1999 Act is also perhaps in conflict with the Right of Persons with Disability Act 2016, where the guardian can be anybody. Now, this not having been looked into by the Delhi High Court, in my humble view, the view will require re-examination. This has not been, I've rechecked from the website of the Supreme Court. This decision of the Delhi High Court has not been questioned or challenged anywhere. So, therefore, in such a situation, keeping the larger picture in view, we cannot have a statutory guardian versus a national guardian battle with different powers. Let us look at it from another perspective. Since we have not signed the Hague Convention on Civil Aspects of International Child Abduction 1980, whenever a child is removed, a parent who brings the child to India goes to the family court under the Guardian Wards Act of 1890, not 1980, to become a guardian to his or her own child. And you want to be declared as a sole guardian and you want to be declared sole custody. This is a very big anomaly that a natural parent goes to the court to become a guardian. But then the question is, that is a situation which is different. And there is, now let's look at it another way. The Guardian and Wards Act 1890 and the Family Courts Act 1890 and the Hindu Minority and Guardianship Act 1956 don't restrict the appointment of guardians to citizens. So if there is a foreign national of Indian origin who comes to India, the guardian judge doesn't say, I'm sorry, you are not an Indian national. Therefore, you can't be appointed a guardian. So I think if we put all these issues in a perspective, in a different way, then this view perhaps will need to be somehow seen in a larger perspective and may require a re-examination, because this, if put in the collective basket of the gamut of the rights of the disabled person and the rights of the natural guardian, I think the statutory guardian may perhaps be a little out. Let's look at it from another perspective. Suppose the statutory guardian appointed is a person who has no time, no inclination, no interest, and he's just been foisted upon this responsibility. Will he be able to perform the look after care of the person with disability better than the natural guardian, who, if appointed the statutory guardian, could do a lot? Now, in the Delhi High Court judgment, they have let the natural guardian retain the person, but with another statutory guardian. What will the statutory guardian do? It's another question which I ask myself. So, let us look at all this in a bigger way, in a bigger picture, and deliberate, discuss, and ponder what can be a plausible answer in different perspectives. So I now keep the floor open for questions, and I'll be very happy to answer anything and have more viewpoints.
Thank you, sir.
Yes.
Those who want to ask any questions, either they can post in the chat group or they can unmute themselves and they can ask the question.
I think let people unmute themselves and ask.
Yeah, it will be an interactive.
So there are plenty in the chat.
So you can unmute yourself and you can ask the question. Anna, sir.
Yeah. Please, somebody wants to ask a question. Please go on.
Mr. Malhotra, thank you very much. This is Ramdas from Bangalore. My question, which I posted on the chat box as well, is in the Sanjay Purohit case, Sunil Purohit, sorry, would it have made a difference if the father had held a guardianship award from the applicable state where he was domiciled in the US before coming to India? Would that have influenced, do you think, the High Court decision?
See, I don't think it would have had, because first of all, the US court would not have interfered, because they would have said the person is not in our jurisdiction, doesn't live here, not domiciled in the US. Child is in India, father is in India, and they have relocated to India after the divorce of the husband and wife. Now, and you must also realize, sir, the person is not a child anymore, and the child has not been abducted, removed, or forcibly taken away from the US jurisdiction. It is by consent of the parents upon divorce that the fathers, that the children, that the parties have relocated to Delhi. So I don't think the US interference would have mattered anyway. They would have put their hands up and said, listen, this is a special person with special needs. The person is not in the US or domiciled here. What can we do? And we don't even know if they have any law compatible to this law in which we have in India, where this petition can even be entertained.
Right. The reason I asked that question is, as a US citizen myself, and being the parent of a special needs individual who's an adult and also a US citizen, and with OCI status for living in India, by virtue of being US citizens, we are, there is no restriction on where we are domiciled. So we could choose to live indefinitely in any other country, and not as long as our US citizenship is not impaired or revoked. In that case, the protection given to US citizens is regardless of their country of domicile. That's the reason I ask if the guardianship has been legally provided in the US, where there is a process for getting it. Would that, in a way, supersede or be taken into consideration in a court of law in India, where there are, for instance, for tax purposes, there are these dual taxation treaties, etc. So similarly, that there would be, an accommodation made for a U.S. citizen in that regard. I don't mean to argue the point. I was just asking for your point of view.
Oh, I quite see your point. But the fact of the matter is that once you invoke the Indian law, the local level committee is going to do an assessment of its own. They are not going to rely on your US court order. They'll say, if you have it, then why have you come to us? So I think invoking the NTA Act in India will be calling for trouble.
Right.
It's best you lie low and you carry on as you are. But if you think it's wrong and you actually need guardianship status under the NTA because you are a parent who can take care of yourself, challenge the provisions of the Act again, these rules and regulations, or and you say that this is unconstitutional. How can they inhibit my right? Because the Delhi High Court judgment, or for whatever it's worth, doesn't take care of the ROPDA and doesn't take care of the UNCRPD. So this is a law which needs to be relooked at. It doesn't stand to reason. It doesn't stand to law made by Parliament in 2017.
Right. Thank you, Mr. Malhotra. Thank you.
Yes.
I request Chandrakant Kale sir to pose your question. Unmute yourself and ask your question.
Yes, I'm Mr. Kale. Are you listening?
Yes,
are you
please.
getting me?
Yes, yes, you're
Okay.
audible.
I have a simple question.
Yes.
I already put it on a chat. The last question is more important for me.
Yes.
All laws are also applicable to persons with psychiatric disability or a problem. If I mean guardianship and so on and so forth. See, National Trust Act probably has defined some 4 or 5 disabilities.
Yes.
But may not be a psychiatric disability falls in this under this law, and probably we cannot we may not be able to get the benefit of this law as far as guardianship is concerned after we are no more. Please.
I think what you are saying doesn't sound to be correct, because in Sunil Podar's case, there was a very clear factual issue that the child was severe mental retardation. So if you look at the provision, if you look at the schedule, you will probably find the description of the diseases, problems, or issues which are covered under the Act. I think if you see the schedule to the Act, you will probably find all the issues which are covered with this. I think it's best that you please. So probably you will find. See, the name of the Act is Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities. So if you look into mental retardation, I think you will find the description of what level. But then even if it is not, it's covered under it. So you could well go and seek the issue here, because I think in the Delhi High Court, from whatever details are available in the judgment, severe mental retardation, disability certificate, US citizens. So this is exactly what we are looking at here.
Okay.
And just to answer the question of the previous one also, the gentleman had legal custody of his son as the primary caregiver, and the child was adopted within the US. So, to answer the previous gentleman's question, if you read the judgment, you will find it's quite like the case you want.
Yes, thank you.
Any next question, please?
Advocate Parimal sir wanted to ask some question, I guess. He had unmuted himself. Parimal sir, just unmute yourself.
Next question.
I request Mahesh Apte to ask this question. I think they are unmuted.
Anyway, I'll just quickly go through. Somebody posed a question that if there is that if there is a person who's in a coma and appointment of a guardian is required to look after his or her affairs, there is a judgment of the Delhi High Court dated 24th of February 2016, Pratibha Pandey versus Union of India, where it is said that where there is a person in a coma and is unable to look after self, then her daughter can be appointed. The son and husband had given their no objection. SDM has inquired into the matter, didn't find anything wrong. So the daughter was appointed as the guardian, as she was able to do all things. So this was the answer which the Delhi High Court gave in a writ petition, saying that because of the peculiar facts of the case, now the court, Justice Rajiv Endlaw says, I should of course not be construed as opening doors of this court and not into special fora, but I choose to exercise my jurisdiction. Now, an inquiry was formed that the petitioner, who is in a coma, 60 years of age, daughter is 36, other two, husband and son, have given no objection. Now it says, owing to the turn which the matter has taken, needs to go into the question whether the action of the trust and local level committee refusing to appoint the daughter as the guardian does not arise. Suffices to say that the Supreme Court has said so and so, so and so. Then the High Court has gone into another decision, and the court has used its powers under Article 226 of the Constitution to appoint the daughter of the guardian. So this is how the matter was dealt with by the High Court. So there is an interference when the national level committee, the local level committee is restricted in its view. So, Shraddha, any other question?
No, sir, I can't find any other question. Anyone wants to ask any questions, they can unmute themselves.
Shraddha, I wanted to ask one question.
Please.
Has this Delhi High Court decision been challenged in the Supreme Court?
Sir, I have gone to the Supreme Court website. I have checked on the Supreme Court website. There is nothing available which indicates that there was a challenge. And I even spoke to the Counsel for the Government of India. She said there is nothing on the website. See, probably the gentleman, the petitioner, Mr. XY, whatever it is, I don't want to name him. He probably felt that he's only getting into more trouble. So it's best that he have these sleeping dogs left. Because you see the judgment of the Delhi High Court is quite strange in the end. It says that we cannot lead the closure of these proceedings. It will be unfair to the person with disabilities. The son is stated to be in the legal custody of his father. The ends of justice would thus appear to merit the following direction. Let the local level committee evaluate the circumstances. Committee may also advise adoption of such further measures. Court leaves it open to the petitioner to nominate an Indian citizen whom may be appointed as a statutory guardian. Statutory guardian, when appointed, shall together with the petitioner be obliged to attend to the welfare and upbringing of the person. Statutory guardian acting together with the petitioner shall be responsible for the discharge of obligations. The aforesaid direction shall not be understood to be as authorizing the removal of the son from the custody of his guardian, the father, unless the local level committee finds otherwise. So this is, I think, a very strange answer that there should be a statutory guardian and he and the father will work together unless the local level committee finds otherwise. I think taking away the care of the natural guardian in respect of such a person with such a disability is more harmful and injurious and conflicts with the UNCRPD and is a violation of the right to life, both of the father and of the person, because you are separating them from family life. You are depriving them of their right to live together. You are depriving them of their rights of life as individuals. So I think this judgment with the directions after holding that only citizens can be guardians, where will you find an Indian citizen to act as a guardian of such a person? And why? What for? The guardian will turn around and say, listen, you have your father with you. Isn't that enough? I think on that question, I can also say, enough is enough. Back to you, Shraddha.
Yeah,
Thank
any
you,
further
sir.
questions?
Yeah, I have a
Any further
question.
questions? Yeah.
Yeah, can I ask?
Yes,
Yes,
please.
yeah, sure,
Okay,
sure.
okay. So my question is, in place of a person, can a family trust be appointed as a as a as a
Guardian.
as a guardian? Yes.
I think you may have a trust, but you will still need a guardian within the trust. See, you need a caretaker.
Yeah.
A trust may be necessary for your property disposal, for selling something, buying something, taking stock of something. But the purpose here is a little different. I think it is more to personal care, though there is property, assets, and management involved also. Now, what can also be visualized is that the person, the natural guardian himself, who is, let us say, is living abroad, can say, I will manage his affairs, property, valuables, assets, but I appoint Mr. X as his guardian to look after him physically, his needs, his requirements, and 24-hour care, because he needs 2 people, 3 people. That is something which a natural guardian can do voluntarily. But to say that the natural guardian, being a non-citizen, is disqualified is wrong. The question which I ask myself is, why can't the natural guardian and the guardian appointed by the trust be joint guardians?
Okay. Yeah.
You see, what is the purpose? What is the objective? The objective is the welfare of the person. It is not a question about nationality and citizenship.
Yeah.
I think the code has gone too far in restricting the right in a legalistic way and forgetting the humanitarian, the benevolent, and the useful purpose which the convention advocated.
Mm.
And I think nobody pointed out to the court that the 99 Act has been superseded by the 2016 Act and the 2000 signing of the UNCRPD by India. So it is a legal discussion. DOR's welfare, benevolence, look after, and rights of the person.
You're right.
It is not a discussion on the rights of the person who needs a guardian. It is more about a discussion about rights of the person who can be appointed as a guardian. I think the cart has come before the horse. See, I think I blame assistance to the court. I act as an amicus. The court needs assistance. Somebody should have opened this can. I did it in Kerala from Chandigarh. And we found a way. The writ court could not see the difference in thinking. Here is a view restricting everything to India. Oh, no, the child will go away from India. The father will take away the child from India. Child should remain within control of India. In Kerala, the bench let their jurisdiction travel to Dubai by creating a space of Indian soil in the Consulate General of India in Dubai and saying the Consulate General, our rights will go there. And we cited judgments where welfare of Indian citizens, illegal immigrants, people with wrongs done have gone across. So it is a question of how parents portray welfare of the person is concerned and construed. The Supreme Court stayed the judgment, but the Supreme Court is still looking into ways and means of giving access to the mother to the autistic person through areas and means where she can have a rented accommodation, etc., etc. So
Yes,
the court may not, the court
yes,
would have been apprehensive of losing control on the child. Yes, yes, yes.
Can I ask a question?
Yes, please. Go
Am I
on.
audible?
Yeah, you're audible.
Yes, you're quite audible.
Yes. Advocate Malhotra, your presentation has been fantastic, but whether we can work on a sort of a checklist or a do's and don'ts, because once when the steps are taken, we cannot retract. And the poor child has to suffer. So whether you can provide a sort of a do's and don'ts in this subject.
Sir, I think somebody needs to challenge this law. Take it to the Supreme Court. Let somebody in the Supreme Court with an open mind and a larger frame of thinking and a perspective looking at all sides needs to look at it objectively. If anybody is game, I will be very happy to challenge this in the Supreme Court of India and say that this judgment needs to be rectified and this issue of interpretation needs to be resolved. When in Section 14 of the Act, there is no restriction on a foreign national to be appointed
because we are torturing the child.
We have to look at the larger picture. So, instead of do's and don'ts, I think just get on to do's and forget about don'ts.
Okay.
This view of being a citizen may be a mindset in every local level committee. Why? Because the local level committee are only going to read what is written in this. They will not think in a larger way. You need a man lettered in law, a retired judge, a lawyer, to expand the meaning. See, these people, as in Hindi, will say, "Wo lakir ke fakir hai." So they will not say, they'll say, you take it to a court. There's no judge element. So this is again, I think, you should have a retired district judge or a retired judicial person. The judge with his judicial training, with his wisdom of rights, with his knowledge of law and acumen, will be able to look at the larger picture in a better way. Now, if you go to a local level committee, they'll say, fill in the blanks, tick mark, foreign citizen, out, rejected. No application of mine. Mechanical rejection.
But the Bar Council or National Law School has a role to play?
Sir, the Bar Council or the national level school can take it up as a pro bono public interest litigation. I can be your lawyer to argue it.
Good.
You can do a pro bono public interest litigation. Think of it.
Right, good.
You must solve the problem for a lot of people who probably have no clue on what to do, where to go. See, the worst part is nobody has any idea. I don't think 95% lawyers would know anything about this. And it's an unknown law. It's only the one who's hurt by it can look into it. But he will be resigned to his fate. Thank Shraddha for opening this up to the world. I will put it on my YouTube channel, and it should go viral. It should go to people. See, we are living in an age where we are talking of rights. fundamental rights of persons. And here is an archaic view saying citizens only. I don't think it works with the times. It doesn't. It doesn't
Yes.
sound consistent with rights as interpreted by the Supreme Court.
We have to
Any
bell
further
the cat.
questions? Yeah.
Thank you. Thank you, sir.
My pleasure.
Any more questions? If anyone wants to ask any question, they can unmute themselves.
Questions are not chargeable, Shraddha.
I think I should put that disclaimer now.
Hello, anyway, you done.
Anyways, we can just wind up. Thanks a lot for giving such a excellent coverage on this topic, sir.
Yeah.
I request my colleague, Advocate Chinmay, to propose the vote of thanks.
And before the vote of thanks, I want the video recording to me so that it goes on YouTube immediately within 24 hours.
Yeah, sir. I think by evening I should get from the cloud, so I'll just forward to you.
Excellent.
Thank you. Chinmay, please propose the vote of thanks.
Thank you, Shraddha. So, it is indeed very enlightening to talk about such a niche area, especially when, like you said, 90% of lawyers don't even know about it, and especially when there's an added layer of complexity when clashing jurisdictions come into the picture, which is already, disabilities is already a very delicate subject, and when complexity such as clashing jurisdictions come into the picture, then it becomes all the more complex. So, thank you for shedding light on it. Thank you for making us all aware of laws and rules that we were not previously aware of. I would like to thank Shraddha and all of our organizing team, and of course, you, sir, for expanding our knowledge today. And thank you, everyone else who actively participated and made this session a great success.
Thank you, Shraddha. I think you have opened the
Thank you.
doors and minds of a lot of people who really needed but had no place to go.
Thank you, sir. Thanks a lot for you, sir, for selecting this topic.
No, it's nice. Why shouldn't we? We are duty bound as lawyers to do all this.
Yeah, because we were discussing for some other topic, and all of a sudden you suggested this topic. This was completely new and unknown.
Well, I have dealt with a matter on this point, so I was quite startled to see what is the thought perspective. Anyway, it was very interesting. Thanks a lot.
Thank you, sir. Thanks a lot. I'll share you the video in the evening.
Okay, all the best. Bye. Thank you.
Okay. Thank you, sir.